Gary DeWaal here, and this is Bridging the Week for July 28th to August 1st, and today is August 4th, 2014. Good morning. The U.S. Commodity Futures Trading Commission showed it knows how to wield a carrot and a stick. 2 weeks ago, the CFTC granted relief to certain obligations under its large trader reporting regime by extending the deadline for filing of certain reports. Last week, the CFTC filed an enforcement action against a futures commission merchant for not complying with other large trader reporting obligations, although the fault seemed to originate with defective third-party vendor software. Ouch! In addition, last week the Financial Crimes Enforcement Network of the U.S. Department of Treasury proposed new anti-money laundering Know Your Customer obligations on certain financial institutions. We have a lot to cover this week, so let's get started. The U.S. Commodity Futures Trading Commission filed and simultaneously settled an administrative enforcement action against J.P. Morgan Securities related to the firm's alleged failure to comply with large trader reporting requirements. In settling this matter, J.P. Morgan agreed to pay a penalty of U.S. $650,000 and file with the Commission within 120 days a sworn statement affirming that the company has systems and controls to enable it to comply with applicable large trader reporting obligations. As an aside, under the CFTC's large trader reporting requirements, future commission merchants, clearing members, and foreign brokers are required to file a report with the Commission each business day for each account, a so-called special account, that exceeds a designated reportable amount. According to the Commission, beginning in 2012, CFTC identified a number of errors in J.P. Morgan's large trader reports. These errors included overstating certain EFRPs. J.P. Morgan attributed these errors to a third-party vendor. Despite promises to fix these errors, they persisted through February 2014. This is not the first case the Commission has brought against a broker for failing to comply with its large trader reporting obligations. See my practical tips for complying on the article version of Bridging the Week on my website. The Financial Crimes Enforcement Network of the U.S. Department of Treasury proposed new rules to require certain financial institutions to know and verify the identity of beneficial owners of entities who are their customers. Potentially impacted financial institutions are those currently required to maintain a customer identification program by FinCEN. These financial institutions include banks, broker-dealers in securities, mutual funds, as well as future commission merchants and introducing brokers in the futures industry. Legal entities potentially impacted by the new rules include corporations, limited liability companies, partnerships, or similar entity structures, whether formed under U.S. or non-U.S. law. Under the proposed rules, relevant financial institutions would be required to have legal entities complete and certify a standard certification form at the time of account opening in order to identify beneficial owners. FinCEN proposes to define beneficial owners as an individual who directly or indirectly owns 25% or more of a legal entity or who has a significant responsibility to control, manage, or direct such entity. Comments on the proposed rules should be submitted to FinCEN by 60 days following publication of the rule proposal in the Federal Register. Both the CFTC and the Financial Conduct Authority of the UK filed and settled enforcement actions involving Lloyds Banking Group entities in connection with their alleged false reporting and attempted manipulation of the London interbank offered rate from mid-2006 through 2009. The Financial Conduct Authority additionally sanctioned the entities for endeavoring to manipulate fees payable to the Bank of England in connection with their participation in a program aimed at helping UK banks during the 2008 financial crisis. The CFTC fined the Lloyds banking entities $105 million US, while the FCA fined the Lloyds banking entities 105 million Great British pounds. This is equivalent, by the way, to 178 million US. Separately, Lloyds Banking Group entered into a deferred prosecution agreement with the U.S. Department of Justice over its LIBOR offenses, agreeing to pay an additional fine of 86 million US. Last week, the Managed Futures Association submitted letters to new CFTC Chairman Timothy Massad and each of the 4 commissioners, setting forth MFA's current priorities. Among other matters, MFA requested the Commission to address several of its concerns related to swaps trading and cross-border issues. MFA also asked that the CFTC consider rulemaking to its interpretation that directors of certain investment funds must register as commodity pool operators, which the MFA believes is wrong, and that the Commission repeal its prohibition against permitting futures customers to establish third-party custodial accounts to maintain their collateral away from future Commission merchants. Last week, ICE Futures US filed a rule amendment with the CFTC to clarify that its speculative position limits do not apply to bona fide hedging positions as defined under CFTC rules or to non-enumerated hedging positions that the exchange concludes are, quote, consistent with the purposes of hedging, end of quote. Requests for non-enumerated hedge exemption should include information showing that the positions, quote, are consistent with risk management strategies for the relevant commercial market, end of quote. And finally, the SEC awarded $400,000 US to a whistleblower who provided information that led to a successful enforcement action against an unnamed firm. In making this award, the SEC overturned the preliminary determination of its claim review staff that it recommended against making this award on the ground that the claimant had not provided the information voluntarily. This action prompted my thoughts about firms maintaining their own internal whistleblower process. Check these out in the article version of Bridging the Week on my website. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the Gary DeWaal & Associates website. Check it out, of course. Until next week, this is Gary DeWaal. Have a great week, and ciao!